You are welcome to our show, Dr. G.K. Goswami IPS. In this live streaming, today we are going to discuss a global perspective on constitutional amendment. You all are aware that in our last discussion, we have discussed in detail about constitutionalism. And in constitutionalism, I have told that Constitution is like a body and constitutionalism is like soul. We will discuss little today also about constitutionalism during this discussion, but we will be providing during this discussion the global perspective how constitution amendment process is available in jurisdictions like America, United States, United Kingdom, South Africa, India, Germany, Australia, and so on and so forth. The purpose of comparative constitution and particularly the process of amendment provide the greater understanding how different jurisdictions have adopted the amendment process. So it's quite interesting. So let's begin, friends. Amendments of the Constitution. We all are aware that Constitution in most of the jurisdiction is the supreme law. It is called the Gerd norm in terms of Kelson's pure theory of law. So if we try to understand first what is Constitution. This is the first and foremost question comes to our mind. So Constitution is the fundamental legal code that defined and organized political setup or political authority and protect people's rights. So there are two major issues. One is how the political system got established and how they operate. On the other side, Constitution also provides the rights and duty of the people of that country. This is an instrument to govern the government. This is the most important part. So Constitution is the governing body of the government. So this is the fundamental to understand here. Albert Van Dicey, the famous legal expert, the legal acumen of United Kingdom, he has said or he has defined Constitution in a very beautiful and meaningful manner. A Constitution is all the rules which directly or indirectly affect the distribution of exercise of sovereign power of the state. That means Constitution actually define or design how the power and authority get divided into various organs of the government, how the government is formed, how people are placed in the system. So this is the larger legal framework for the governance of the country. The Constitution, according to Dice, has two important parts. And this is very, very fundamental to understand, especially those who are appearing for different examinations, maybe PCS mains, maybe civil service and all. The legal rules, they may be written or unwritten. So they are visible parts sometimes or they are unwritten also. But other than these written or unwritten conventions, the conventions are also very important. So there are two parts of Constitution. One is which is written or unwritten like in United Kingdom. Other than that, convention also play very important role. And you might be aware that many things are not written in the legal documents. So conventions, the traditions are also very important, integral part of the Constitution. Aristotle has also defined Constitution. According to him, Constitution is the arrangement of the magistracies in the state or the way political power is organized. Thomas Paine has said that a constitution is not the act of government but the people constituting a government. Again, it is the governing body of the government. John Austin said that a constitution is a set of commands issued by the sovereign. He further said that these commands, if not being obeyed by the people, then some kind of punishment may also follow. Then Strong said, C.F. Strong, a constitution is a body of fundamental principles according to which a state is governed. So by and large, these are the fundamental rules, regulations by which a government functions. A government is formed. What kind of government has to be, it will be defined, and it is the supreme power or supreme law of the land. Now, the core constituent of the constitution, this is a supreme law of the land. As I said that it is the guardian of, defined by Kelsen in his Pure Theory of Law. It establishes basic structure of the government, the organs of government. We are aware that there are three organs of government. One is the legislature for making the laws or amending the laws. Then the executive to execute the laws, rules, regulations. And then the third one is the judiciary, the very important organ which actually adjudicate the disputes and also interpret the law, and sometime if the need be, then they make the law. That is called judicial or judiciary made law. Then it defined relationship between the state and the people, the fundamental right and duty as we have already said. Then protect values, core values like supremacy of law, rule of law, democracy, separation of power, free and fair election, and so on and so forth. And of course, the power to have judicial review. That is the most important part of the Constitution. Framework for making and changing the law, that is amendment. So amendment is most important part. Otherwise what happens, that suppose there is any government, and of government, as I said, they have the legislative role also. So suppose they become in majority, definitely in democracy if they have the majority, then only they can form the government. But if there is no mechanism actually, then they can completely wipe out the Constitution itself. So what are the limit of the amendment? How far they can amend the Constitution? That is most important. And if you see the different country, their constitutions, then we realize that there are attempts at different point of time. There were tussles in the power, and in the Constitution, the tussle was that the government in power always try to mellow down the effect, the power of the Constitution. So this tussle is very, very important, and India is not an exception. Right from 1950 itself, from Golaknath to many other cases, Minerva Mill, so that around 30 years of journey has a vast, turmoil, I can say. And that was quite interesting, which laid down the principle of basic structure principle. So what it was, we will discuss in detail. So amendment process, yeah. Now before that, let's see what type of constitution can be. So there are different ways of understanding the types. One may be written constitution and another may be unwritten constitution. So most of the country have written constitution like India, UK, South Africa, Australia and many more. However, UK probably is the stand-alone jurisdiction which has unwritten constitution. So what does it mean? We will see how this unwritten is being understood. There are different set of laws, different set of instruments which actually constitute together the law of or the constitution of the United Kingdom. It does not mean that unwritten means that nothing is written. Many things are there, but exactly in the form of constitution, it is not there. How it operates, we will see in the next slides. Then there may be another classification, rigid and flexible. Rigid, difficult to amend, like in United States, it is quite difficult. There are hardly 16 amendments so far since 1789. Then there may be flexible, like in United Kingdom. India also considered to be a flexible constitution because of its little easy method of amendment. Although there are certain, caveat saying that whether it is flexible, but I think it is in between. Codified and uncodified, whether rules are consolidated in a single text or spread out. So these are different way how the constitution can be classified. Now, importance of the constitution. Why constitution is supreme? What is the reason? So let's see before we begin the amendment part, because many times these things which I am talking, they may help the students, the legal acumen, to brace, to buttress their argument, maybe in the court, maybe in your answers, maybe in your argumentation in any discussion at any forum. So constitution basically, it is the expression of social contract between state and the people, the social contract theory. It reflects actually what was that. Then it puts limit on the rulers. As I said, that it governs the governors, or it governs the government. Then it ensures rule of law. Privacy means supremacy of the law. Then it guarantees freedom of the people. It organizes power checks, that is separation of power, check and balances between state and center. And not only that, the check and balance between three organs, the legislature, the executive and judiciary. Then supremacy of law I already mentioned. A constitution is not just legal text, it is a living instrument for democratic governance. It reflects national identity. Yes, this is the most important, it is dynamic. It is a living instrument. So what do it mean by dynamic or living instrument? That means it actually adopts the need of the changes in the society. Society is dynamic, so law cannot be static. And that is the reason the amendment in the constitution becomes very, very important to address the need of arise due to social changes, the need of the people at that point of time. With the generation, things changes. So if the constitution is highly rigid, then those expectations of the new generation may not be fulfilled, and that is why the dynamism of constitution or any law is the primary requirement for any good quality of constitution. Now, let me just recapitulate what we discussed about constitutionalism. As I said, that constitutionalism is the operative part of the constitution. How constitution operate? What is the will of the government? What is the will of the political power to execute constitution? There may be constitution well written, but if there is no will power, there is no constitutionalism, then that becomes the hollow vessel. That is the point. Constitution is a political and legal philosophy. Legal philosophy provides constitution, making of the constitution, but its execution depends on political philosophy. How the people in power, the political parties in power, how they give the space to implement the law in right spirit and letters. Then key principle of constitutionalism, limited power of the governing political identity, no arbitrariness, no favoritism, accountability of the government to public, that is public means we the people, like in our preamble. Then rule of law, supremacy of law, then constitution is the guarantor. Then review to struck down unconstitutional law, that is judicial review basically. There are check and balances of power between different organs. then in the federal system between the union and the states, then protection of fundamental right, freedom and liberty of the individuals, then judicial independence and popular sovereignty. Why constitutionalism is relevant? It prevents tyranny of rulers and majoritarian. Then it protects rights, especially minorities, dissenters, and vulnerable sections like minorities, as I said, then women, children, the otherwise enabled people. Then it enables democracy, it supports good governance, it promotes stability, ensures maintenance of law and order, peace and tranquility. Amending power, that is judicial review. That is very, very important part. So these two things are interconnected, and amending power is also very important feature of the constitutionalism. Now we are reaching to the core subject what we are going to discuss. Till now we have given you a base, how constitution is defined, what is constitutionalism, and how with different type of constitutions are available in the different countries. So broadly we have discussed so far. Now what is amendment? Amendment is basically a change, either formal change, either it is addition or deletion or some kind of modification. It made according to prescribed procedure. Constitutional amendment has a very set procedures. You cannot deviate from them until unless it is approved by the competent authority. Then purpose of amendment, basically as we discussed, the society is dynamic, so law cannot be static, and so is with the constitution. Law must be dynamic, never static or rigid. So this dynamism, basically it adapt the social change, social need or political reality. It further expand or limit the rights of the people also, and particularly it actually make the limited government. So untamed government is always a very, very authoritative system. So limiting the power of the government is the core subject of the constitution through constitutionalism. Then to restructure the institutions, to respond to crisis or court rulings, to correct drafting errors or ambiguity. Sometimes there may be some kind of ambiguity or some mistakes, so that also need to be, and that has to be done by way of amendment process. Then to introduce international treaty and other factors. Sometimes the country may become the signatory of any treaty, conventions and all at international level, so they may be adopted. And I think the very good example, not necessarily in the constitution, but adoption in our legal system, we can cite that after UNCRC in 1989, India became the signatory, and afterwards we have adopted and we have introduced on 14th November 2012 the POCSO Act of 2012. The basic feature of the amendment process, that is very important part. Yeah, this is the slide. So I have given a comparative chart. So first is whether constitution is written or not. So constitution set out the amendment procedure. Like in India, we have in US Article 5 deal with amendment process. In India, it is Article 368 of Indian Constitution 1950. Then higher threshold. Amendment demand a more demanding procedure than passing ordinary laws. So in some country like in US, the process is very tedious. It demands lot of approval by 2/3 majority and all. We will discuss it in detail. Then division of power. In federal system, state plays critical role. US need ratification by 2/3 of the states. There are 50 states in United States at the present. So division of power is important between the union and the states for the purpose of amendment. So few amendment may be done by the union itself, that is parliament, but certain amendment which are critical and needs the approval by the state or the constituent part of the nation. Then comes the entrenched provisions. Few provisions of constitution need more difficult procedures. Like in Germany, basic law forbid amending core principle. Like in India, we have the basic structure concept. So basic structure concept in India and in Germany, the basic law, right? These have very close nexus. The judicial review is important because judiciary is the custodian of law per se and particularly the constitution. And if there is no embargo, there is no rider on the government, they can change anything, and sometimes there is a fear across the globe that if the amending method procedures are not settled, then government in majority and super majority sometime they may change the constitution to that extent that it may lose its importance. Now let us see one by one the jurisdiction. The first is United States. Procedure for constitutional amendment in United States, as I already mentioned, Article 5 of US Constitution, which was adopted in 1787. It has two steps, friends. The step 1 is the proposal. And in United States, as I said, that it is very tedious process. So in step 1, the proposal for amendment comes after 2/3 majority of the both houses of Congress. And the name of the Congress are House of Representative and another one is Senate. Like in our country, Raj Sabha and Lok Sabha. Lok Sabha is like Senate. Usual method. Then National Constitutional Convention called by the Congress when requested by 2/3 of the state legislature. So these are the proposal actually. And this second part has never been used by United States so far since 1789. After the proposal is ratified, then the second part is step 2. The proposal is ratified by 3/4 of the state. There are 50 states, so there is need of 38 states to ratify that. And it is not the ratification by the general public, it is the ratification by the legislature of the state. Then the ratifying convention in 3/4 of the state used once so far to repeal prohibition in 1933. So you can well understand that the proposal by second method has never been used, and ratification convention in 3/4 state has only been used for repealing the prohibition in 1933. So you can understand how difficult the process of amendment in Constitution exists in United States. US President has no formal role, no presidential veto. Normally we believe, and that is a fact, that American President has huge power center. He is epitome of power in the political scenario in the country. But in amendment, he has no veto power. That is the beauty of US Constitution. Then constitutional amendment in United States, if we see the statistical part, then so far, by and large, more than 11,000 amendment proposals have been placed before Congress since 1789. 11,000, just imagine. You might be considering, oh, this is a very big number, but see the fate. Only 33 amendments have been referred to state for ratification. So at the level of ratification, 33 could only be referred. That means at the proposal stage only all majority, like almost 99%, got settled. Then out of 33, only 27 could qualify the ratification. That's the difficulty. And the last amendment, if we see, was in 1992 for raising the pay. That was the 27th amendment. So since 1992, now almost 33 years, there is no amendment in the Constitution of United States. The key example of amendment, very important to listen, because many of you in various examination and to strengthen your argument, you can cite the Bill of Rights. These are very important. They are almost say fundamental rights. The first 10 amendments were ratified in 1791 itself. Then 13th amendment, abolition of slavery, was done in 1865. 14th amendment, equal protection in year 1868. Then adult suffrage to black male was in 1870 by way of 15th amendment. Then in 19th amendment, women's suffrage in 1920. Just see, India since beginning was having the adult suffrage, but the American woman got after long time. From 1789 till 1920, they were waiting without having voting rights. 21st amendment, only one amendment passed by the state convention for repealing the prohibition. So this is the actual scenario. That was in 1997. Now let us see what were the cases which were important for the viewpoint of amendment process in the Constitution of United States. We have already discussed in detail the case of Marbury versus Madison, 1803. Here the judge was appointed by the outgoing President James, and Marbury was the secretary to the newly appointed president, and he refused to issue the commission to take over as the Supreme Court judge. And Chief Justice of United States Supreme Court, Chief Justice Marshall, famously said a law repugnant to the Constitution is void. That means the judgment was that not issuing the commission by Madison was wrong. Marbury was entitled to become judge since he was appointed as per the procedure established by law. So due process was adopted. That was different, that he was posted at what time? He was posted just a night before the swearing in was organized for the newly elected president. Then another important case was Coleman versus Miller of 1939, where United States Supreme Court held that Congress decide what is reasonable time for ratification. In Hawke versus Smith in 1920, the US Supreme Court held that ratification is a federal function and not subject to state referendum. In Dillon versus Gloss in 1921, it was observed that Congress set a time limit for ratification, 7 years become standard. So these are certain important points. Now the challenges. What are the major challenges in the amendment process of United States? Friends, it is extremely high threshold. We are aware that for amending the provision in Constitution of United States, one has to get 2/3 support of the Congress plus 3/4 of different states. That means 38 states has to ratify, and that is very high level. That's the reason very few amendments could get the finality. It makes cross-party agreement very rare. It is a small state has huge leverage. Despite the population size, every state has equal right or equal status in ratification of referendum. No basic structure concept like in India. Now, legal question regarding the judicial review in United States. The question is, does US Supreme Court has power to review the substance of the amendment made by legislature? The answer is no. Since there is no basic structure concept in United States Constitution, only check is that amendment follow Article 5 of the US Constitution. So far, the US Supreme Court has never invalidated any amendment. So, as I told, the law has two parts. One is the procedure and another one is substance. So, here the amending power, despite the fact that US observe due process of law, but in judicial review, the court does not have the power to see or to evaluate the substantive part of the amendment. They can only see the procedure adopted as per Article 5 of the US Constitution. So, this is a very, very important point to be observed. Now, having said this, we have completed the broad arena of United States process of amendment in the Constitution. Now, let us go for United Kingdom. We are aware that United Kingdom has unwritten Constitution. But what is unwritten and how it is reflected, let's see. US does not have any written codified constitution like other countries. United Kingdom Constitution is indeed a collection of various instruments. So here is the point. Don't think that it is just like fluid. There is nothing for the purpose of constitution or constitutional value. So these are different instruments like statutes, Magna Carta, Bill of Rights. This statute, Magna Carta, it is 1215. It is wrongly written. Correct, please. 1215. Bill of Rights, 1689. Parliament Acts of 1911 and 1949. And Human Rights Act of 1998. Common law principles, that is judicial precedence. Common law country means those country which follow the precedence or the judgments, their ratio decidendi by the superior court. So that is called common law precedence. Constitutional Convention, royal prerogative. So these actually constitute the Constitution of United Kingdom, which is actually unwritten, but these are the guiding principle, guiding force, guiding statutes, guiding instruments. No specific amendment procedure in the United, because there is no prescribed or there is no written Constitution. That is why there is no prescribed or defined process of amendment for Constitution in United Kingdom. No difference between ordinary law and constitutional law. This is very, very important. They have kept constitutional law and ordinary law on the same pedestal. Most of the country like India, United States, others, the constitutional law stands much higher than the rest of the legal documents. But in United Kingdom, because all the important instruments they constitute the constitution. That is why there is no discrimination between constitutional law and ordinary law. The parliament is supreme because there is no constitution as such in the written format. That is why parliament is supreme, unlike in India where constitution is supreme. This is the difference between India and various other countries as well, vis-a-vis United Kingdom. Now, these are certain instances of constitutional amendment in United Kingdom. Broadly, Bill of Rights in 1689, very old, almost 100 years before United States in 1789 they introduced their constitution. Then Parliamentary Acts 1911 and 1949, then European Communities, then Human Rights Constitutional Reform Act, European Union Withdrawal Act, Brexit, which was quite interesting. I will tell you one case related to that, when the then Prime Minister of United Kingdom has advised the Queen to Senate the Parliament for 6 weeks. What are the consequences? We will talk that. So, now the ruling on constitutional amendment in United Kingdom, these are certain important cases. Actually, I just thought that there are maybe some legal experts, the judiciary, maybe the students, the faculties, they may need some relevant case laws. So these are the case laws, they can go in detail. This is Mad Jim Bamto versus Larder Burke, Privy Council case of 1969, where Parliament legislative supremacy cannot be limited by convention. So Parliament supremacy in United Kingdom is ultimate. Nothing can challenge it. Then R versus Attorney General of 2005, Lord Stein and Hope suggested Parliament sovereignty might be limited by rule of law. So here the important point is, which is the supreme? Supreme is the constitutionalism, and that is, here you just see the rule of law, the supremacy of law. So despite the fact that Parliament is supreme in United Kingdom, but the supremacy of law, rule of law, that are the ultimate, and actually speaking, impliedly speaking, the rule of law is even supreme to Parliament. Why? Because Parliament is also guided by the rule of law. Then another case is Factor Time Limited versus Secretary of State of 1990. EU law could override conflicting UK law. So here the EU laws were given supremacy over the local UK laws. This is important case, Miller Brexit case. Court reasserted the supremacy of parliamentary procedure over executive prerogative. The PM could not bypass Parliament to trigger Article 50 or prorogue Parliament unlawfully. We will talk little more about this case. Then what A.B. Dicey said about the UK constitution. A.B. Dicey said what the Queen in Parliament enact is the law. So if you see, almost the definition resembles with Austin definition of law. Austin says the law is command of sovereign. Here Dicey says that in England what Queen enact in the Parliament is supreme. So that is the resemblance. The Lord Stein in Jackson versus Attorney General in 2005 said that rule of law enforced by the court is the ultimate controlling factor on which our constitution is based. So here it is the law enforced by the court. So it means that rule of law here again is supreme, because judicial power is meant here to execute the rule of law. Lord Bingham said that rule of law as the foundation, suggesting unwritten principle can control parliament indirectly. What I have said exactly has been mentioned by Lord Bingham. That means it is the law of rule of law which predominate even the parliamentary powers, because parliament only function under the ambit of the rule of law. Then Verman Bogdanor said UK constitution is evolving. Evolving means that it is dynamic, it is organic, it always adopts changes. So this is the organic part. Now let us see the challenge in the constitutional amendment process in United Kingdom. No formal entrenchment. There is little reliance on conventions. No written limits of amendment. That means they can amend any part, whether they are ordinary law or constitutional law. Conflict with international law, and Brexit was the very important time, 2018, 19 and all. Then judicial power are also undefined, but in United Kingdom, the judicial power are enormous, and they actually interpret, they actually make the laws. That is why the common law concept was developed in United Kingdom. So in making and defining the law, I think United Kingdom magistracy, or you can say the judiciary, has the supreme authority in my view. You can see the Jackson 2005 case, Miller 2. There are two cases, 2017 and 2019 for Miller by the Supreme Court. And you will be surprised, we have already discussed that UK Supreme Court was established after, you can say, amending the House of Lords. The Supreme Court of United Kingdom was established 2009. And rather than saying the Chief Justice of the Supreme Court, they call President. The unique flexibility, the takeaways, if we see the unique flexibility, it is world's most flexible constitution. On the other side, we will see which are the most rigid constitution, probably German constitution and UK constitution. There may be more, but they are on the extreme side. So on the, perimeter how the constitution process for amendment exists. So on the one side, the UK constitution, which is easiest to amend. On the other side, United States and German constitution, which are very, very rigid for adopting constitutional amendment. No basic structure doctrine. Basic structure doctrine is the innovation of Indian judiciary in 1973 through Kesavanand Bharati case. We'll discuss it later. Then it increasingly observing judicial boldness. So lot of rules, lot of doctrines has been developed because of the court intervention. Their innovations has also been adopted. The evolving practices, always organic system in the lawmaking. Then reliance on good faith. Good faith we have discussed in our reel. Good faith actually with the correct intention and with due care, due diligence. And good faith is the core to have the life in place in the society. If good faith is not there, then everybody will doubt and nobody will help, nobody will work thinking that I may be implicated for having no ill will, but if something goes wrong. So good faith is a very, very important tool in administrative system. Not only in administrative system technically, but day-to-day life also good faith is very important. Now let us go to India. Yeah. Amendment in Indian Constitution. The Indian Constitution of 1950. Remember, we adopted it on 26 January 1950. Part 20 titled Amendments of the Constitution, particularly Article 368 of the Indian Constitution. It allows Parliament to amend Constitution where the Parliament can introduce addition, deletion or any modification. There is no timeline bar for passage once introduced. If amendment is being introduced, there is no bar. Of course, if Lok Sabha is dissolved, then it die out by itself. Then special constitutional convention, no. There is no convention. President assent is always required if Parliament finally pass the bill. There is limited role of the states to certain amendments like federal structure and all. Then judicial review, Supreme Court has power to review amendment. So these are certain features. Basic scheme of amendment, the type. So there are three types. One is simple majority, then another is special majority, and the third one, which is most difficult to get amendment passed by the Constitution, is special majority plus ratification by half of the state. So we have half the state, not like 2/3 of American system. So in simple majority, majority of the amendments are adopting this first category, simple majority. Certain provisions can be altered by ordinary simple majority in Parliament, like formation of new states, change of boundaries, etc. Special majority needs majority of total membership of each house and 2/3 of members present and voting. So simple majority, but 2/3 those who are voting at that time. Then abolition of right to property, 44th Amendment of 1978 may be an example. Then the third category, when the amendment affects federal structure. That's very important. Federal structure means the relationship between the union and states. The segregation of their powers, their authorities, like there are three lists, union list, state list, concurrent list. So there are various components, federal structure. We will talk sometime, but it is a very, very important part. And 7th Amendment of 1956 was example of this third category, where states were reorganized. Now, having said that, we have passed more than 75 years now, and we are living in Amrit Kal period. But in the recent past, since beginning, there were tussle for amendment process, particularly the fundamental rights, and the tussle was between the Parliament and our Honorable Supreme Court of India. So what were the tussle? Particularly three major events happened. The first was power of Parliament to amend fundamental right. My dear friends, just see the socio-economic status or structure of India when we got independence and we adopted our Constitution. We became the Republic India. The scenario was that major resources, particularly the major chunk of the land, were with the Jamindar. Jamindar was the landlord, and by and large, more than 70-80% resources were in the hands of few people. And they were exploiting the rest of the population. So, the then government was committed to bring certain reforms, land reforms. According to that, the very first amendment in our Constitution was introduced in year 1951 itself for land reform. But whenever any matter went to Supreme Court, the Supreme Court generally take a call saying that we are the country adopting the procedure established by law as mentioned categorically in Article 21 of our Constitution. What is that? Life and liberty of a person cannot be taken away without observing the procedure established by law. Procedure established by law, underline. That means this also indicates the judicial review power in consonance with Article 13 and 21. So read Article 31 along with Article 21 and then you understand, because 13 tell you that our Constitution provides the power of judicial review to our judiciary, and what type of judicial review? That is procedure established by law. On the contrary, UK has the due process of law. Due process, the court has power to review both substance as well as procedure. But in our country, till 1978, my dear friends, till Maneka Gandhi case was decided, we were adopting only and only procedure established by law, not the due process. Although significant footprint you can see majorly in Gorakhnath case, then R.C. Cooper and many more cases, but I want to restrict our discussion to this level of Constitution amendment process until 1967. Again I repeat, before Gorakhnath there were several judgments like Sajjan Singh, and prior to that there was other cases also. We will mention that with time. But till Gorakhnath case, the Supreme Court was saying almost for 16-17 years that Parliament has all power to amend any part of the Constitution, including fundamental right. That was the stand by the Honorable Supreme Court. But after 17 years, the Constitution became young, almost 17. So the newly baby born was grown up. And in Gorakhnath case, the matter was reversed. The major problem came when Zamindari Abolition Act was there. So we have Article 31 in our Constitution, that was right to property. That means right to property was fundamental right. It means that you cannot take away my property. But government want social justice, distribution of resources, and that is why the Article 31st was repealed. And that was the crux of the problem. And there were several amendment 1st, 4th, 17. But all were ratified by the Supreme Court. It was the Gorakhnath case which actually turned around the wheel. Gorakhnath versus State of Punjab in 1967, the Honorable Supreme Court said that fundamental right cannot be amended at all by the Parliament. So there were complete embargo. Now, what about Article 31st, which had already been repealed? The basis for Gorakhnath judgment was that constitutional amendment, it has the status of law under Article 13 and hence it cannot be amended. You cannot abridge those rights which have been mentioned in Article 13, and amendment is basically law. It has the status of law and hence you cannot, because it falls under Article 13. To nullify the impact of Gorakhnath, as I said that there was a tussle between Supreme Court observations and Parliament amendments. So the 24th Amendment was introduced by the then government in 1971, by which the Golaknath judgment was nullified and it asserted that Parliament can amend fundamental right. So I believe that till 1967 the Supreme Court was giving all power to the Parliament, saying that any part of the Constitution including fundamental right can be amended. It was Golaknath case which put the rider saying that you can amend any part except fundamental right. To nullify the impact, Amendment 24 in 1971 was introduced, which has revived the power of Parliament to amend any part including fundamental rights. So this is the brief. Now let's see what happened again. Then this is the important case, case Anand Bharti. And it is a highly celebrated case where 13 judge constitutional bench decide, and this case was, my dear friends, was very thin margin, 7:6. That means 7 judges out of 13 gave the verdict, whereby that was the ultimate judgment, but on the contrary 6 judges gave the otherwise judgment. So what was that 13 judgment bench? The 7 judges held that it introduced doctrine of basic structure, and I think this is the innovation of our Indian judiciary, which has been well recognized across the globe in constitutional jurisprudence particularly. Parliament can amend any part of the Constitution including fundamental right, but again underlying but the basic structure of the Constitution cannot be compromised, cannot be destroyed. So now the ratio of this judgment was that, look, Parliament can amend any part including fundamental right, but they have to protect, they have to respect basic structure. What is basic structure? The court, the judgment remains silent. So till date, although there are so many interpretations, but there is no watertight compartmentalization to define what is basic structure argument. It limited the amending power. The Chief Justice said, Chief Justice was Justice Sikri, who was the father of the retired Supreme Court Judge Arjan Kumar Sikri, A.K. Sikri Sahab. He was also, A.K. Sikri was in Supreme Court Judge, and he also delivered very important judgments over the time. So Chief Justice Sikri in 1973 observed every provision of the Constitution can be amended, provided in doing so the basic foundation and structure of the Constitution is not changed. So basic foundation and the structure of the Constitution cannot be destroyed. After that, another tussle. So Golaknath was nullified by 24th Amendment in 1971. Then came case Anand Bharti, which was nullified by 42nd Amendment in 1976. And this amendment, my dear friend, is also called mini constitution because it is a huge, arena. Various amendments were put together in this 42nd Amendment. The most important for our purpose, for the purpose of provision of amendment in the Constitution, was it entrusted unlimited power to the Parliament, especially clause 4 and 5. There were clause 4 and 5 which inserted into Article 368 of the Indian Constitution, and the most glaring part of this 42nd Amendment was that it debarred judiciary from judicial review. They says that amendment done by the Parliament cannot be judicially reviewed by the Supreme Court. Now again the tussle. Minerva Mill case. in 1980. Minerva Mill versus Union of India. So these three cases, my dear friends, you should remember very well. One is Golaknath in 1967, followed by Amendment 24 in 1971. Then Keswanand Bharti in 1973, followed by Amendment 42nd in 1976. Then Minerva Mill case. Minerva Mill versus Union of India, it struck down part 3 and 4 of the Article 368, which revived the judicial power of the Supreme Court. So, the Amendment 42nd, which debarred Supreme Court from judicial review to examine the nature of amendment, it was revived by Minerva Mill case. It affirmed that limiting amending power itself is part of basic structure. Observation of CJI Chandrachud. That time CJI was the Chandrachud, and he was the father of our ex-CJI Chandrachud Sahab, D.Y. Chandrachud. Limited amending power is itself a basic structure of the Constitution. So that means that Parliament does not have unlimited power. It has the limited amending power, and that is the integral part of basic structure. There are certain observations of the jurist. I have tried. You can remember them to reproduce in your answers, in your argument at various platforms wherever required. Palkhiwala, a very renowned, I think the most celebrated advocate we have in our country, one of them. The Constitution is not a mere political document, but the supreme lex which governs those who govern us. That means the Constitution is the governing body of the government. That is what exactly he said. Then G. Austin, who is US historian, he called about Indian Constitution that Indian Constitution is a seamless web of fundamental right and directive principles. He praised the basic structure doctrine as a unique Indian innovation. So this is unique Indian innovation what Austin has proposed. Now, the celebrated professor, I have high regard for him. I have lot of blessings from him. Professor Upendra Bakshi sir, he said that basic structure doctrine as necessary bulwark against majoritarian excesses. So that is, and he is also considered, Professor Bakshi, as one of the best legal brain India has produced in recent past. Then current status. Let us see what exactly the whole discussion, what is the crux. So this is the slide says the crux. Amendment is the explicit power of the Parliament under Article 368 Part 1. Amendment are not law. That was actually said in Golaknath under Article 13. So fundamental right can be amended, but the basic structure cannot be destroyed. President must assent once passed by the Parliament. No veto power to our President of India. Supreme Court can review amendment to secure basic structure principles. So the judicial review power for examining the crux or the content of the amendment is very well restored. These are certain cases, as I said, Sankari Prasad in 1951, then Sajjan Kumar, Golaknath, Keswanand Bharti, Minerva Mill, I.R. Kohlo. I.R. Kohlo is also very important. Rest of the cases I have already discussed with you. I.R. Kohlo in 2007, even 9th schedule are subject to basic structure test if inserted after 24th April. That means after Keswanand Bharti case. So Kohlo case is also important. Now an overview of 368, just to recapitulate what exactly it is. Who amend the Indian Constitution? The Parliament only, no other authority. Who assents? The President of India but has no veto power. Who ratify? half the state if required. There is no general referendum or public referendum in India. How protected? By judicial review to protect basic structure. So basic structure is the protection clause. Then Supreme Court power. Supreme Court can strike down amendment if destroy basic structure. Amendment of fundamental right, yes, but it cannot destroy basic structure. And then popular referendum, no, we do not have that. So I hope that you have understood the Indian legal system for amendment in the Constitution. Now we should switch towards South Africa. South Africa has so many close connections with India. They have suffered the colonial rule like us. They were also brutally suffered with apartheid, the racism and all. So that was another social stigma attached to them. And after long battle by various freedom fighters like Nelson Mandela and all, they got independence in 1990s. And then they established their constitutional law in 1996. They got independence and established they constituted their constitution. So it is well written and codified law. That is, constitution is a codified and written document which advocate democracy, equality and human rights. About constitutional amendment, Section 1 and Section 74. In South African Constitution, they do not have the provision of article, they said sections. So Section 1 and 74. There are three levels of amendment. Amendment of Bill of Rights, then amendment under Section 1 or 74, amendment under other provisions. So these are the types which I have written. Just understand that what it is. Amendment type. First, amendment Bill of Rights, the chapter 2. And amendment of Bill of Rights means that almost human rights you can say, or the fundamental rights what we have in our constitution. So it needs 2/3 majority in National Assembly and Section 74 and support of 6 out of 9 provinces. So Bill of Rights, that is fundamental right, are very cumbersome process of amendment. It is not easy because it needs 2/3 majority of the states as well. However, if we see 18th Amendment, right to basic education, maybe the example where that right to education was introduced. Then second is amendment under Section 1 and 74. So these are the provisions why and how the amendment in the Constitution take place. So it is like how Article 368 in Indian scenario, how that can be amended. This is the scenario in South Africa. 75% majority in National Assembly supported by 6 out of 9. That means 2/3 majority or ratification by provinces. The example may be Republic of South Africa is one sovereign democratic state was introduced. Then third, amending other provision. It is simply by 2/3 majority in National Assembly, and some provision also need provincial consent. So these are the three broad categories of amendment, and the first for Bill of Rights, that is fundamental rights, is most tedious and needs higher approval by the sitting members in the House and 2/3 majority of the states. Now the challenges in amending South African Constitution. High threshold make major structural change difficult. Tension between popular demand and entrenchment rights. The judicial gatekeeping. This is important, this is unique, which I want to explain, otherwise rest of the things we have already discussed. The court can review whether proper amendment procedure was followed. So that is gatekeeping. If you remember, this gatekeeping concept was also introduced almost at the same time in Dover test for forensic evidence evaluation by the court. Court also act like gatekeeper. That was in 1993, although it has no direct connection, but I just to refresh your memory. So court can review whether proper amendment procedure was followed, but cannot block a validly passed amendment, unlike in India. So they can just see whether procedure was adopted, but they cannot go for quality or the substance. However, in India, we can have the procedure as well as substance, but to that extent that basic structure is intact in Indian Constitution. Then there are certain cases by the Superior Court. The first one is ex parte chairman of the Constitutional Assembly. It was certification of Constitution in 1996, the same year when the Constitution was adopted. The court held that a Constitution is not simply a statute with mechanically define the structure of government and the relation between government and the governed. It is a mirror reflect the national soul, the identification of the people's ideal and aspiration. That is actually nothing but constitutionalism. So they say that merely Constitution itself is not enough, but it is the spirit, it is the constitutionalism which actually revolve the Constitution around the needs of the people. Then Doctors of the Life International versus Speaker of the National Assembly in 2006, Constitutional Court emphasized that amendment must comply with constitutional principle of public participation. UDM versus President of Republic of South Africa, the substantive change must follow the constitutional strict amendment process. So Supreme Court generally look here in South Africa whether procedure has been duly observed or not, but they do not go for substance like in Indian context. Their takeaway from South African constitutional provision of amendment are the textual entrenchment. South African constitution founding values are entrenchment in the text, section 1 plus section 74. So these are the provisions under which the constitutional amendment can be observed. A strong federal element in various amendments, the will of the state also been recognized. So their concurrence is necessary. Then no unlimited amendment power, judicial review is in place, then balance of rigidity and responsiveness. People's Constitution. South African amendment system is a negotiation safeguard. It locks in democratic values through high threshold and judicial oversight, protecting the Constitution as promised to never return to oppression. So it is a very balanced type, and I believe that for various purposes, I think South African Constitution is also a very well written document and testament of human liberty and right and duty based implementation of law. Now Australia. So friends, let's see Australia also. We have discussed India, US, UK and South Africa. So the next one is Australian Constitution. It is Commonwealth Constitution of Australia was adopted in 1901. Amending section is 1 to 8. Steps are number 1, Parliament proposes an amendment must pass both houses of federal parliament by an absolute majority, or if one house passed the proposal twice within 3-month gap and other house rejected, the Governor General may still submit to the people. So this is a kind of upper hand given to the people's representative chamber of the parliament. The step 2, referendum. Referendum by the public. The proposal must be put to referendum of the Australian people within 2 to 6 months. Once the proposal is passed, the time limit is within 2 to 6 months for the public referendum. To pass, it must get a double majority. National majority more than 50% of the valid vote, and state majority at least 4 out of 6 states. So you see that the difficulty is that 50% of total vote casted by the people during referendum, and among them 4 states out of 6, that means 2/3 state independently should ratify it. I think it is very, very difficult task. Why high bar? rigidity to protect federal balance between state and commonwealth, popular consent to limit sudden centralization of power. Since 1901, that means since the constitution was in place, 44 proposals, but only 8 succeeded. Success rate is only 18%. So you can see how difficult is the amending provisions are in Australia as well. So in my opinion, the most difficult, most easy is UK, then I believe India, then South Africa, then US, and now Australia. Let's see about next. We will talk about Germany also. Very interesting. The challenge in amendment process of Australia, as we said, the double majority, very, very difficult to achieve. The low public engagement, many people vote no due to confusion. Federal state conflict for power sharing. No basic structure doctrine. I think basic structure doctrine only exists in India. So in all the countries, this feature which is most vital, innovation of Indian judiciary is nowhere. Australian High Court has no power to strike down a valid amendment. Like in India, our Supreme Court has power to strike down the amendment if it violates the basic structure features. But the highest court, Australian High Court, has no power to strike down the valid amendment. Valid means if there is a procedural fault, then they can. But if it is validly done, then they have no power. The takeaway, it is highly rigid by design, double majority, stable but inflexible, judicial evolution, because they can examine the procedural part, no basic structure, state and public role to block amendment. Public education and awareness is important, because if public is not aware, they may not be understanding what is actually the subject matter of amendment, and that is why the referendum may pass or block the important amendment sometime. In nutshell, we can say that Australian constitutional amendment process is a textbook example of federal rigidity. The double majority protects both democracy and state, but also lock the constitution into the past, shifting constitutional change to court instead. Now, the last but not least, German. So now I think another 5 to 7 minutes we will conclude. My friends, I am grateful that you are with us always like ever. So features of the German constitution, Weimar constitution earlier, before World War II. That means till the Hitler. So Hitler period was governed by Weimar constitution from 1919 till 1933. And pre-World War II, that was having easy amendment process. The constitutional is called Grundgesetz, basic law. So we will call here basic law, because in most of the books, generally it is referred as basic law of 1949. After the demise of Hitler in 1945, precisely on 29th April, the provision for amendment in basic law exists under Article 79 and 23. What is Article 79? The formal procedure, 2/3 majority in both houses, that is called lower house, which is Bundestag, and upper house, Bundesrat. And Bundesrat, which is upper house like Rajya Sabha in India, they represent lenders. The explicit eternity clause, that is core principle, cannot be amended at all. It is close to basic structure. So I think basic structure has some relation with section 79(3) of German constitution, which says that core principle cannot be amended. In Indian scenario, the basic structure also reflect core principles. Core principles include eternal clause. They are the division of federal into lender. Lender is the state actually. basic principle laid down in Article 1 and 20. Article 1 means human dignity inviolable, and Article 20 means democracy, rule of law, federalism and social structure. If you see this clause, the core principle clause, they are almost replica of what? Basic structure in Indian Constitution propounded by Honorable Supreme Court in Keswanand Bharti case. The challenge: balancing rigidity and flexibility. Although in my opinion it is most rigid. Interpreting the eternity clause, it is vague, like the doctrine of basic structure in India. There is no rigid framework. There are again organic, dynamic. Integration with EU laws, that is another problem because it has highly rigidity in bringing amendment, and EU laws and other changes are difficult to incorporate. Federal lender balance, as I said, lender means land is singular, lender is plural for the state. So federal state balance is also important. Note, lender is singular, lender is plural, and land is singular word for the state actually, or federal state of Germany. Lenders exist long before modern Germany. So they are very powerful units. Basically they were like Kabilas and all earlier. A few have histories as kingdom, duchies or free cities. Total 16 lenders at present in Germany. Like state we have in US there are 50 states. In many other countries like South Africa has 9 and all, right? So likewise they have the lender. The takeaway: double safeguard, high parliamentary threshold plus explicit eternity clause. That is the core principle theory. Then judicial enforcement. The FCC guard the eternity clause. Like in India, the Supreme Court guard the doctrine of basic structure. Here the core principles are guided by EFCC. It is adaptable, not fragile. Integration with Europe is difficult, as I said. Then lesson for other democracy inspired India's basic structure doctrine. The self-defending democracy. I believe that somehow or other, Indian innovation called doctrine of basic structure is inspired by the core principle of German constitutional amendment system. So with this, now let us come to conclusion in very tabular form. US, it is high bar for formal change. Major changes happened by Supreme Court intervention. United Kingdom is most flexible. India has written text plus unwritten judicial limits, that is basic structure, and that is why it is uniquely hybrid. South Africa, it is deeply negotiated entrenchment, never again guardrails. Germany, gold standard for explicit unamendable core. That is core principle which said. Australia, federalism, double veto, very few amendments could succeed. Court fill the gap by creative interpretation. So these are a very, nutshell means outcome what we have discussed. With this, now we came to conclusion, and I think about 1 hour and 25 minutes, less than 1 hour and 30 minutes, we could conclude. And I sincerely request to share our content with your friends, with your groups, and subscribe the channel. This is for you. And if you submit your suggestions, your observations in chat box, it will be great help. If you have something in mind to advise us on what topic we should come up further, I will be very happy and we will respect your advices. Further, we will be coming soon by next week with other such topics in this mode of live streaming where we interact directly with you. In addition to that, every Evening at 6 p.m. we have the small version for around 3 minutes reels. So please watch them regularly. We are with you to enable you to withstand in the modern era of democratic setup, in the era of cyberspace, where there are a lot of boons, but there are a lot of challenges as well. So having said that, namaskar, good